Hi, my name is Jeff Morgan. I'm from Dallas, Texas. As many people know, one of the issues we are fighting for in the state of Texas is the repeal of no-fault divorce, otherwise known as unilateral divorce. And people have asked me, what do you mean by unilateral divorce? No-fault divorce we've heard of. What about unilateral divorce? What's the difference? And simply stated is that unilateral divorce is a divorce which is initiated by one person against his or her spouse who does not want the divorce. It is an imposed divorce, it is a forced divorce, it is a unilateral divorce. The spouse against whom the divorce is filed loses 100% of the time, because the spouse against whom the divorce is filed does not want the divorce, and yet in the state of Texas, the person filing for the divorce wins, period. The state of Texas always sides with the person filing for the divorce. The idea behind no-fault divorce initially was that it would be a mutual consent thing. The two people wanted to say, you know what, we don't want to have to manufacture a reason for a divorce. We're just mutually agreeing that we both want to leave this marriage. It's not worked out the way that we wanted to. I'm going to forget about the children that are being affected by that right now. But this was the idea that somehow if you had two adults that were married and that wanted to leave the marriage voluntarily with mutual consent, they could. What this has evolved to, however, is that unilateral divorce is when one person imposes divorce on a person who does not want to be divorced. That person wants to remain married. The individual filing for the unilateral divorce may be a person who's running around on his or her spouse, maybe a person who is doing a number of things that are causing problems and damages to the relationship, and this person gets to hide behind this statute called allowing for no-fault or unilateral divorce. In the Texas Family Code, section 6.001, the way that this usually works out is that one person says that our marriage is insupportable. What does insupportable mean? There is absolutely no definition given to insupportability in the Texas Family Code. So what it really means is anything that person wants it to mean. My wife is not happy that I'm running around with other women, therefore our marriage is insupportable. The husband is not happy that she's dating richer men, therefore the woman would say, well, our marriage is insupportable. I'm the one causing the behavior, but it's insupportable because of his response or her response. And in the meantime, what they can do then is they can file for divorce and then claim insupportability and win the divorce 100% of the time. When I say win the divorce, what I mean is this, that the people get divorced. The person who entered into the marital contract had the anticipation that the marriage would last for the entire lifetime. However, with insupportability, any spouse can end a marriage for any reason, for no reason whatsoever, can make up a reason, and the state of Texas always sides with the person who is initiating the divorce 100% of the time, period. The reality is that no-fault divorce, about 75% of the cases, one person is being forced into a divorce situation. And what's even worse, if you look at it from the context of the family, in the majority of instances, by far even larger than 75% of the children, the divorce is being forced upon the children. The children have no rights in a unilateral divorce. It's whatever the one spouse, the one father, the one mother, whoever it is, decides that he or she wants, that will be forced upon everyone, and it will lead to the destruction of the family. Now, the state of Texas always sides with the person wanting the unilateral divorce. And the question that I have is, does the state of Texas have the constitutional authority to mandate unilateral divorce? And I'm going to argue, no, the state of Texas does not have that authority whatsoever, nor does any state in the entire United States have the ability to allow for a unilateral divorce, to sanction a unilateral divorce. And this will be based on the contract clause of the United States Constitution. The contract clause that I would argue prohibits the state from interfering in such a way as to impair a contract, a marital contract between two individuals. What is the contract clause? Article 1, Section 10, Clause number 1 of the United States Constitution, the clause prohibits the state from passing any law that impairs the obligation of contracts. No state shall pass any law impairing the obligation of contract. Now, the contract clause allows individuals in the private realm to create contracts between one another. The contract clause allows states to regulate contracts. So in other words, you cannot have a contract that goes against public policy. For example, if you had a contract for child labor or a contract that goes against the Texas public policy or any state's public policy, the state has a right and the ability to regulate a contract like that. You cannot have child labor, for example. We have child labor laws. You cannot have a contract in which you will be hiring a 6-year-old child and forcing him or her to perform labor for you. That is legal for a state to regulate a contract. However, what we are not talking about is regulating a contract. We are talking about impairing a contract. With unilateral divorce laws, the states, the state of Texas, every state in the country is actually committing an unconstitutional act. The Constitution makes absolutely no distinction between one type of contract and another. The contracts are all looked upon as the same. Contracts are legally binding. If you enter into a contract, you are obligated to fulfill the contract, and the state is not allowed to prevent you from doing so. So the first question that some people might have is marriage really a contract? I mean, we're talking about marriage. Is marriage really a contract? The answer should almost be self-evident, but for many people it's not. So yes, marriage is a contract. Although marriage ceremonies may have romantic and often they even have religious aspects, a marriage itself is a state-sanctioned agreement that carries legal rights and responsibilities for spouses. It is very much a contract. A contract is something that is a legally binding agreement between parties to do something or to not do something. Once it is created, it must be determined if there's any problems legally with the contract that call into question its validity, and assuming not, the contract is valid, and if a breach of contract occurs, then there is the question of what type of damages should be assessed against the person who broke the contract. Marriage has all the elements of a contract. Basically, you're looking at 3 elements: the offer, the acceptance, and the consideration. The offer needs to be serious. The person who makes the offer is willing to uphold the agreement. If you went to a dating site and if you saw a man or a woman there said, "I'm looking for somebody to marry," that's an invitation for somebody to say, "Hey, this person is looking for somebody to marry. I'm looking for somebody to marry. Maybe we can get together and discuss this. And maybe we won't like each other. Maybe we will. Maybe we will enter into a contract later. Maybe we won't." But an invitation, an advertisement is not an offer. An offer is when, so for example, you propose to somebody, "Will you marry me?" And then you have the acceptance. First you have the offer, then you have the acceptance. The counter offer is not an acceptance. So if I say to somebody, "Would you marry me?" and she says, "Well, I would marry you on this condition and this condition," that is not an acceptance. That is a counter offer. The counter offer creates a new offer that needs to be accepted. If the person says instead, "Yes, I will accept your offer and become your husband or your wife," that is the acceptance. Finally, there is the consideration. What is a consideration? The consideration is something of value that is given or exchanged. All parties in an agreement to a contract must give something of value for the contract. Consideration can be a promise to do something. It can be a promise to pay something. There may be an exchange of money. There may be an exchange of gifts that are tied up to this contract. The offer, the acceptance, and the consideration. In Texas, when you have these things that take place in order to get married, you have to apply for a marriage license. And the reason for this is that the state is giving you a license by which they will be registering your marital contract. You make an application to the state, you pay a fee, and within 90 days after receiving this license, you have the obligation or the opportunity to get married, to consummate that contract. If you don't do that within 90 days, you have to reapply for another license if you want to be married under the laws of the state of Texas. That is a regulation of the contract. That is not an impairment of the contract. Now, if you are 2 people that say, "We don't believe that the state should issue license," you can enter into your own informal marital agreement. But you still need to register it with the state. And in accordance with the Texas Family Code, you would write this: I solemnly swear or affirm that we, the undersigned, are married to each other by virtue of the following facts. On or about such and such a date, we agreed to be married. We made this private agreement with each other to be married. We're letting the state know we have become married. And after this date, we lived together as husband and wife. And in this state, we represented ourselves as married to one another. So if I met my neighbor and I said, this is my wife so-and-so, and she met a friend, said, oh, by the way, this is my husband, even though we have not had a ceremony, we have informally agreed to be married, we have represented ourselves as married, we are married. Since the date of the marriage to the other party, I have not been married to any other person. This is part of what you affirm to the state. Since the date of the marriage to the other party, I have not been married to any other person. This declaration is true and the information in it which I have given is correct. Now, these again show that the importance that the state of Texas is placing upon this contract, this marital contract between two individuals. Further proof that marriage is a contract in the state of Texas is that the minimal age for marriage in Texas is 18. Why 18? What's magical about the number 18? Well, because in Texas, if you are under the age of 18, you lack the capacity to make a contract. A minor who signs a contract can't honor the deal or can void the contract simply because he or she is under the age of majority. So under the Texas Family Code, Chapter 1, General Provisions of Marriage, Subchapter B, the Public Policy, Section 1.104 says the capacity of the spouse. Except as expressly provided by the statute or by the Constitution, a person, regardless of age, who has been married in accordance with the law of the state, has the capacity and power of an adult, including the capacity to contract. So in the areas in which it was expressly provided by statute or by the Constitution, a person, regardless of age, who has been married in accordance with the law of the state, has the capacity and power of an adult, including the capacity to contract. So this is coming under marriage. They have the capacity to contract. So the state of Texas says this is a marriage contract. But it may still be that some people need to be persuaded whether marriage is really a contract or not. So I looked at another state's laws. The state of Washington, the Revised Code of Washington, makes it explicitly clear that marriage is a contract. In the Washington State Legislature, the Revised Code of Washington, Section 26.04.020, it says this: marriage is a civil contract between two persons who have attained the age of 18 years and who are otherwise capable. Marriage is a civil contract between two persons who have attained the age of 18 years being the age in which you can enter into a contract, and who are otherwise capable of entering into a contract. Marriage is a contract between two people. It is a bilateral contract. If two people willingly enter into a bilateral contract, one person is not allowed to change the terms of the contract after the contract has begun and been initiated without the agreement of the other party. You can't agree to modify a contract if you are both in agreement. You cannot agree to modify a contract if one person protests or does not give the consent to the modification of the contract. The state of Texas actually also realizes the obligations of the marital contract. In Title I, the Marriage Relationship, Chapter 2, under Subchapter F, the Rights and Duties of Spouses, Section 2.501, talks about the duty to support. Each spouse has the duty to support the other spouse. Also, a spouse who fails to discharge the duty of support is liable to any person who provides necessaries to the spouse to whom the support is owed. So in the state of Texas, not only do we have a contract, but we have the idea that each spouse has certain duties in that contract. You need to fulfill your end of the contract. And if you don't, and if somebody else has to take your place to provide certain things, you owe that person because it was your duty to provide for your spouse. So the whole point is to say marriage is a contract. Of course it's a contract. If it is not a contract, why does it need to be legally terminated through divorce? The state of Texas is saying that the marital contract, which we all agree is a contract, we as a state of Texas are going to say that contract means nothing. If one person claims insupportability, we will take the side of that person and say that the contract will be dissolved. Most people who marry until death do us part. At least that's the way that I've seen. Most people say that when we get married, we are not going to be married for 2 years and then have a renewable marriage at the end of 2 years. We're going to have a temporary trial marriage and then find out if it works, and if it doesn't work, we will cancel our marriage at that point. But we have a very specific time. This is a 2-year marriage. We don't have people that say, you know what, I want to have a nice roommate while I'm in college, so we are going to be temporarily married while we're in college, and once college is done and we leave the same dorm, we will say that our marriage contract is over. Nobody looks at marriage in that light. People look at marriage as being a lifelong decree. Or how about people in the military? We're serving together overseas. We are going to get married to each other because if you get married in the military, there are benefits that come along with recognition of marital status. In fact, the government does recognize marital status. It gives tax benefits. It gives certain other provisions, benefits, societal recognition that you are married. They are honoring your contract in that manner. But if two people in the military stationed overseas said, you know what, we're both in Germany for a couple of years, why don't we get married to each other while we're in Germany? That way we'll have more money coming to us, we can live off post, we can do this, we can do that, and at the end of 2 years, we will just say our marital relationship ends. That is not what we think about when we think about marriage. Marriage is not designed to be a temporary living arrangement. Marriage is not designed to be a listing of a friendship. In the state of Texas, however, you would actually have more security in a temporary marriage than what you do in a permanent marriage. If you had a marital contract that said, we will be married for 4 years, you can plan your life that you will be married for 4 years. This contract has to be fulfilled for 4 years. In a normal marital contract, the state of Texas says, we have this thing called insupportability. We have not defined it. Any spouse can say for any reason or for no reason whatsoever at any time during the marriage, this marriage is insupportable. This is insupportable and it's that person's fault. It's not my fault for my behavior. It's insupportable because of that person. And I get to sue for divorce. And then you have to go through all of the legal proceedings to dissolve the contract. What happens in unilateral divorce, one person gets to say, I want out of this contract, and the other person has no defense against it. In bilateral contracts, there are provisions for people to leave the contract. There are provisions for breaches of contract. What takes place is that the person who breaches the contract owes some type of compensation for not fulfilling the contract. In the state of Texas, it doesn't happen that way. The state of Texas will side with the person who wants to break the contract for any reason, for no reason whatsoever, for a made-up reason, and say that person wins automatically. The person who says, wait a minute, I signed up for this marriage. This was a lifelong endeavor. We are going to have children in this marriage. We are combining our efforts. I'm going to support you while you get your college degree, and then when you go to work, I'm going to be able to get my college degree. Together, we are going to create this wonderful home, this wonderful life for our family. And one person says, well, I got my college degree, I've got my job, and guess what? I don't want to fulfill my end of the contract. This marriage has now become insupportable, and the state of Texas says, we're with you all the way. Again, the contract clause of the United States Constitution says this: no state shall pass any law impairing the obligation of contracts. Marriage is a contract. When you enter into marriage, you have obligations to that contract. The state of Texas, the Texas Family Code, acknowledges that you have duties to the contract. However, the state of Texas and every state in the United States actually violates the United States Constitution by passing laws which allow for the impairment or the destruction of the obligation of contracts. And we can go back to this too. There's a famous court case going back to the 1800s, in fact. Dartmouth College, the Trustees of Dartmouth College versus Woodward. And this particular case deals with the contract clause. and limitation of the powers of the state. So the issue at stake was this: under the Constitution, can a state legislature change the charter of a college? Here's what was at stake. At stake was whether Dartmouth College would remain a private school or whether it would become a state school. The state wanted to change the charter of Dartmouth from a private college and make it a public college. In 1769, the King of England granted a charter to Dartmouth College. Now, it's 1769. This was before we had our Constitution. Prior to the Constitution, we had the King of England granting a charter to Dartmouth College. This document spelled out the purpose of the school, and it set up the structure to govern it, and it gave land to the college. In 1816, the state legislature of New Hampshire passed laws that revised the charter. The state legislature of New Hampshire passed laws to change the terms and conditions of the contract. These laws changed the school from private to public. They changed the duties of the trustees. They changed how the trustees were selected. Everything got changed. So the trustees decided to file suit. They claimed that the state legislature violated the Constitution. In particular, they violated Article 1, Section 10 of the Constitution, which prevented the state from impairing, that is, either weakening or canceling a contract. How was this case decided? By a 5-1 margin, the court agreed with Dartmouth College. The court struck down the law, so Dartmouth continued as a private college. Chief Justice Marshall wrote the majority opinion. He said that the charter was, in essence, a contract between the king and the trustees. The charter was a contract between the king and the trustees, and again, this happened before the United States Constitution was brought into existence. Even though we were no longer a royal colony, the contract is still valid because the Constitution says that a state cannot pass laws to impair a contract. The opinion of the court after mature deliberation is that this is a contract, the obligation of which cannot be impaired without violating the Constitution of the United States. This opinion appears to be equally supported by reason and by former decisions of this court. What was the impact of this decision? Historians believe that this decision greatly encouraged business investment and growth. Corporations are also chartered by states. If states can't pass laws to impair those charters, those businesses are more secure. They are also more apt to attract investors, employ workers, and to add national prosperity. And I would add the same thing about marriage. If two people make a marital contract, they come and they pledge their vows before each other. There is an offer, there is an acceptance, there is consideration exchange. They register with the state saying, we have done this. This is our contract for us. We are registering with the state so that we are legally recognized as having entered into a contract. And this can also be done by the fact that she changes her name from Miss to Mrs. Something has taken place legally. It was a legal change of status. In such a situation, the state cannot impair that contract. The insupportability clause in section 6.001 of the Texas Family Code, which allows a person to divorce another spouse to relieve himself or herself of the obligation of the contract, with the state siding with that person, is an unconstitutional act and should immediately be revoked. Marriage is a bilateral contract made between two people. Throughout history, no bilateral contract could be unilaterally changed. There has to be the agreement of the two people to amend the contract together. Unilateral divorce says one person gets to change the contract according to his terms or her terms, breach the contract, and the state says, that's good. The state is not allowed to do that. Any type of laws that permit this unilateral divorce, this destruction of the marriage contract, are unconstitutional according to the contract clause of the United States Constitution, Article 1, Section 10, Clause 1, which states, no state shall pass any law impairing the obligation of contracts. Thank you.